Hi, I'm Dr. Joyce Alberts, clinical psychologist working in private practice New Zealand. And I have questions. I have questions about lots of things, but in particular, I've got on a little bit of it, down a rabbit hole around the Karen Reid trial, which was concluded just over a year ago. And so it came to a not guilty verdict in 2025. This is after two trials. So the first trial was conducted in 2024, and then in 2025, a special prosecutor, Mr. Brennan, was brought in by the Massachusetts Attorney's Office to lead the prosecution. Mr. Brennan apparently is an experienced defence attorney, and he was brought in this case to prosecute Karen Reid, or attempt to prosecute her for the alleged causing the death of John O'Keefe, which Mr. Brennan failed to do. But my questions are, how can certain things occur in a courtroom in this day and age? I'm not going to show you the video because I do not have consent to do that, but I am going to read through some of the transcripts. And this is a transcript. The video is titled Karen Reid Defense Asks for Mistrial Over Intentional Misconduct. It was published on YouTube on the 10th of June 2025. And this is due to concerns that Special Prosecutor Hank Brennan intentionally misled the jury, making comments about John O'Keefe's sweatshirt. I would encourage you to go to Court TV to watch the actual video, because it is classic. It is classic of Robert Lissy. At the start of this particular clip, you will see Robert Alessi deliberately putting on black gloves because he's going to handle evidence. And this is evidence that was held up in front of the jury and comments were made. So I'll read through the transcript. It's not very long. It's only a few minutes, and I will jump forward a little bit. So, and I'll jump to the most relevant points in the transcript, but I really would encourage you to look at this video. So, Attorney Alessi starts off with, Your Honour, the defence moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. And what I'd like to do, Your Honour, this regards the hoodie. And the representations and questioning by Mr. Brennan, and what I'd like to do and need to do, Your Honour, is to have two documents marked as exhibits, and then I'm going to use Exhibit 88, which is in evidence, which is the hoodie, which is why I'm putting on the evidence gloves, and it will become quite obvious very shortly what the issues are. All right? So what are the things that you want to have marked? So that's the judge asking that. All right? So what are the things that you want to have marked? And he wants to have marked two documents that were taken from the criminalist's file. And this was Miss Maureen Hartnett's notes regarding cuttings from the hoodie sweatshirt that is in the crime lab folder. And also with the permission of the judge, he then asks to hold up the actual sweatshirt. So Mr. Alessi points out, so what he's talking about is, so it is that there are no holes in the back of the sweatshirt. There were no holes on the back of the sweatshirt. That's only part of it. But that is the fact. That is in fact the case, Your Honour. And this is in relation to what you saw as Attorney Brennan questioned Dr. Wolf with regard to the hoodie sweatshirt that has, before this part, it was actually shown in a large plastic casing. It was in this large plastic casing, which I've never ever seen. It certainly wasn't presented that way in the first trial, and I've never seen any exhibit in a plastic casing. So in the plastic casing for the trial, this is what happened. Attorney Brennan held up the casing with the hoodie sweatshirt, went to the back of the hoodie sweatshirt, and then didn't give us an opportunity, because you're supposed to show, if you're going to show the witness something, you're supposed to show it to the other attorney. So in this case, Mr. Brennan should have shown what he was about to show Mr. Bull, Dr. Bull, in the witness stand. He should have shown to Mr. Jackson first. And he didn't give, Mr. Brennan did not give Alan Jackson an opportunity to see that. So Mr. Brennan takes the hoodie in the sweatshirt, in the casing, and without notice shows it to Dr. Wool and shows the back of the hoodie, which has certain holes, and I'm going to limit calling them holes to do this chronologically. I'm going to refer exactly to what they are in a moment. So, of the hoodie, all right, thank you. It's obvious that these are the cutting holes cut by the criminals. So Mr. Brennan shows Mr. Wool the hoodie sweatshirt in its plastic casing, shows in the back of it where there are holes, suggesting that these holes were caused during the what happened, which was allegedly that Karen Reid struck her boyfriend with her the rear of her Lexus, and that as John O'Keefe fell backwards, this onto the ground, and this allegedly caused the injury to the back of his head, that this caused holes to the back of the sweatshirt. Mr. Brennan did not show Alan Jackson beforehand what he was going to show to the witness in the witness stand. And if he had, it probably would have been objected to, or especially in that moment in front of the jury, to say, look, this is the way the sweatshirt got damaged. It was actually during investigation that the criminals cut the holes in the back of the sweatshirt for testing. And Robert Alissi is wanting to have this clarified for the jury so that they understand what happened here. So as it goes on, I'm just going to pause for a moment so I can get to the correct place. So on January 29th of 2022, it was alleged, and it was I'll go back and clarify this, sorry for fluffing around. So this was unmistakable. It was purposefully done, and the intention was to have the jury conclude that the holes in the back of the sweatshirt came from events that occurred on January the 29th, 2022, when in fact the Commonwealth, Mr. Brennan, well knows from its own documents, from its own criminal list, that these holes in the back were caused by the criminalist as part of the examination and sampling of the hoodie. What could be more egregious? What could be more misleading than that? And what could be more important for context than that fact that the alleged collision never occurred? And I'll go on. So he asked for a mistrial with prejudice due to the behaviour of Mr. Brennan. So at the end of this, I'm just going to pause again so I can flip through to the last bit. So it is put to the judge and put to the court that there must be instructions given to the jury relating to what Mr. Brennan had said. So effectively, the judge denies the motion to dismiss or declare a mistrial, and agrees that instructions must be given to the jury. She says, this is judge, your rights are saved regarding the mistrial. And Robert goes, I disagree with you on that, Your Honour. I'm not going to go more into the argument, but I appreciate the opportunity to provide perhaps some further. And she goes, okay, I'll hear you. Go ahead. So he goes on to make an argument and then she says, I am giving an instruction that they cannot consider it for this purpose. I'm allowing the two documents that were put into evidence, I'm allowing these to be put into evidence. So it's not a stipulation, it's from me, which I think is more forceful. So the judge is saying, well, if she makes the statement, rather than the two attorneys, Mr. Brennan and Alan Jackson, saying, look, this is what we agreed to, she is going to make a statement to the jury. So she is going to instruct the jury that the holes did not come from events on January the 29th, 2022. These holes were made by the criminalist, Miss Harnett, during the course of her inspection and sampling of the sweatshirt on May 18th, 2023. She instructs the jury that they are to be really mindful that the holes were made by the criminals, not what Mr. Brennan inferred when he showed the back of it to the witness in the witness stand. So again, I ask the question, how can something like this occur? How is it that in our courts today that things of this nature seem to continue to happen? Now I'm going to pause again for a moment. Just going to pause again for a moment. So carrying on with my questions about how can things that I saw happening in the Karen Read trial happen in a modern trial. I'm going to be sharing a screen with you in 2 seconds. So just clear that. And I'm going to introduce someone else. So I've already introduced Shannon with 1S Burgess, who was employed at the time by a company called Aperture. So Aperture is a company in the United States that provides engineering and consultation. I'm having a look, accident reconstruction. My computer is going so slow. Accident reconstruction, administrative law, biomechanics, construction engineering, digital forensics, economic consulting, graphics and animations, human factors, premises, and the last one, product. I say premises liability and product liability. So this company, and I'm just going to scroll down to the right person. If I cannot back. Apologies. I did have this all lined up. I'm going to introduce you to a gentleman who gives evidence after Shannon Burgess in the trial of Karen Read 2025. And I can confirm, because I have gone through all of the people listed on the Aperture website, Mr. Burgess is no longer employed by Aperture. So at the time he gave his so-called expert evidence, Shannon Burgess misrepresented his qualifications, stating he had university degrees that he did not hold. In fact, the university degree named on his CV doesn't even exist. And I'm just going to pause because my apologies, I'm having problems with my printing and it keeps wanting to print off a large document. I keep cancelling it and then it starts again. So I'm going to share my screen and introduce to you Judson Welcher, and give you his background and his qualifications. So you're going to see on the screen shortly a section of the Aperture website as it currently is shown. So this is Judd, and you're going to see him in a moment in the trial. And when I click on Judson, you'll see that he's an executive vice president for this company. So he holds a very senior role in the company. And his area of focus is accident reconstruction and biomechanics. You can see he holds a PhD in biomedical engineering, Master of Science in biomedical engineering, and a Bachelor of Science in mechanical engineering. So highly qualified and experienced as an expert witness. Now, during the 2025 trial, when I accessed this website, individuals such as Judd Welcher, or Dr. Welcher, their CVs and the information had the stamp across it, not, and I will show you what I mean by this, not for expert designation. So let me show you. I just opened up his CV. So remember, Shannon with one S, his CV became problematic during the trial because his qualifications, simply he didn't hold them and they didn't even exist. So you can see across this particular CV, it still says not for expert designation. I'm not sure why that still reads like that, but that is the way it is. So my question, Dr. Welcher is obviously a highly experienced, highly qualified biomechanical engineer. He has given evidence as an expert witness in multiple trials in the US and works for under contract to, say, for example, insurance companies when they're wanting to know how did this motor vehicle accident happen or how did this person get injured. And it's suggested that sometimes these experts are described as guns for hire, that they will mould their testimony and present evidence to support whichever side hires them rather than remaining neutral and acting as an expert witness to support the court. So remember, this is what Shannon Burgess did. He, in fact, altered his report, changed data during the trial, and said that he did that out of his own initiative when his report clearly stated that he did this as requested by Mr. Brennan. So I'm asking these questions, how can this happen? And at the beginning of this video, I showed you the response from the defence, from Karen Reid's own attorneys, when Mr. Brennan showed a witness on the witness stand the back of the sweatshirt, inferring that the damage to that sweatshirt, the back of the hoodie, occurred as a result of Miss Reid reversing her vehicle into John O'Keefe, causing his death. So now I want to go back to share screen again. Just move myself away from here, and forgive me for all the tabs I have open. As attorney Melanie Little would say, it is rather drafty in here. I have too many windows open. Okay, so this is the question I have around the type of evidence that someone like of this particular quality of qualifications and experience can do this. Let me show you. We're just coming to the end of...
In any of the videos that you have to show Mr. O'Keefe's vehicle after the defendant's life.
going to move into the next section here. So this is a reconstruction of the incident where Karen Reid reverses the vehicle, and in that particular section, Dr. Welcher says that there's just no evidence of her tail light being broken at that point when she reversed into John O'Keefe's vehicle, and in fact there was no pieces lying in the snow. So let's see what other evidence Judge Welcher shows to the jury.
The different pieces of evidence, conclusions about a collision in this case.
Absolutely. Slide 104.
Okay.
So this is a,
It's 105, Dr. Welch?
I'm sorry, 105, yes, sorry. Slide 105. This is a picture of Mr. O'Keefe's right arm, forearm, hand, and wrist. In anatomy, your arm, this is from, so you can see in my right hand here, I have a glass. Here's a glass.
Let's just pause that. So I want you to look very, very carefully at what you see on the screen here. Here you are going to see that, and this a forensic expert was very, very proud of this, and the way he describes it too. He's about the same height, 6'2", as John O'Keefe was, and he's wearing exactly the same clothing: the cap, the hoodie, the sweatshirt, the jeans, the shoes. I'm not sure if he was wearing the same socks, and I'm not sure if he's wearing the same boxers. But in this particular section of evidence, Dr. Welcher is going to demonstrate how he conclusively came to decide that Karen Reid had reversed her Lexus, but they even bought the same model Lexus SUV. So this isn't Karen Reid's one. This is one that this company, and remember, Judson Welcher is the executive vice president of this company, and they purchased this Lexus. Now, anyone around the world knows that Lexus is like the top end of the Toyota range. These are high-end luxury vehicles. These are not cheap vehicles. You can see that he's going to explain how he's holding his arm. Then you're going to see here he's now taken off the hoodie, and he's again holding his arm in a bent position. And let's see what is shown to this jury, because I have questions.
It looks similar, same location. And then in the lower right photograph, what I've done is I've rolled up my sleeve, taken the sweatshirt off, and I'm going to look at how this contact pattern lines up. So the first set of slides, I'm simply standing next to the Lexus. We know we have a broken taillight. We know I have scratches on Mr. O'Keefe's arm. I'm seeing how those may or may not relate to the height and position of the taillight.
Okay, so he's demonstrating to the jury. This is a PowerPoint presentation that he is using, which is why he talks about different slides. And here you can see, again, he is standing at the rear of this SUV, this Lexus, and he's showing how the arm is going to line up. He's standing in a way. You can see him standing upright here, but you're going to see clearly in a moment how he leans into the vehicle to ensure that the position of his arm will match where the taillight is, allegedly to cause the injuries that you saw on the arm. So watch what he does.
Dr. Welcher, if you could back up one slide, I have a question. In the middle photograph,
I'm not going to back up to that slide. Let's move forward.
Damage to the rear of the Lexus. We know we have lacerations in Mr. O'Keefe's arm. So I'm trying to see if there's any correlation between all the lacerations on Mr. O'Keefe. We know we have a broken taillight. We know I have scratches on Mr. O'Keefe's arm. I'm seeing how those may or may not relate to the height and position of the taillight.
Dr. Welcher, if you could back up one slide, I have a question. In the middle photograph,
I'm trying to move forward.
of the Lexus, What do you call that?
I call it a wind wing. I mean, it could be a wing.
Allegedly, this is what caused the
Okay.
injury to John O'Keefe's right eye. So they're alleging that as he
Air
was
dam.
struck
Another.
by the back of the Lexus, that wing.
Okay, so, and then set about to do a little bit of testing. First test you're gonna see is me just walking backwards or actually sideways into the Lexus. What I've done is I've painted the Lexus right rear taillight called grease paint on where you end up after that. We just don't have enough information in this case to determine all that information. We know the taillight was broken. We know the glass was
Stop sharing
broken.
and
We know we have damage.
stop that. Okay. So I recommend that you go to the trial channel and watch that for yourself. I did stop it because I didn't realize that it was actually still on the screen was the injury to John O'Keefe's arm. So you saw the injuries, which the prosecution alleged occurred by the back of Karen's SUV colliding with John O'Keefe and his arm. Remember his arm, he had a sweatshirt on. So while Dr. Welch is using a bare arm, and it doesn't make sense why that he did that, because the paint transfer would have gone to the sweatshirt anyway. I just have so many questions around what was the thinking and the rationale of this. And he paints some grease paint onto the tail light, and then you'll see that as he stands there and the SUV is backing up slowly, because of course he doesn't want to get hit and knocked off his feet by this alleged speed that they said that John O'Keefe got struck. Remember, the jury found Karen not guilty. They agreed this did not happen, but this is what the prosecution tried to convince the jury. So he's painted the grease paint. He stands at the back of the SUV, and as the SUV comes, you see him lean into it and position himself so to get that paint effect. And you would have seen the yellow on the hand, yellow paint on the hand. That's as his hand made contact with another portion of the SUV. How scientific is that? Well, I don't know, maybe a high school or intermediate primary school science project. This is a biomechanic. And I'm scratching my head going, what scientific analysis is this based on? At the end of that, you would hear that Dr. Welch says he can't give exact information on the what happened after that moment, because they simply don't know how he was standing. He's assuming this is how John O'Keefe would stand with his arm like this, holding this glass. He's assuming that because of the injuries he sees. So he said, based on the injuries, he must have been standing like this when he hit the rear of the vehicle. So therefore, I'm going to do this non-scientific experiment, non-biomechanic or engineering experiment to show you how paint will transfer from the taillight onto the area of the arm that was injured. And I'm going to do that wearing the hoodie, the cap, the hoodie, the sweatshirt, the jeans, and the exact shoes, exactly the same clothing. John O'Keefe, for what purpose? What's the scientific reasoning behind that? I'm just blown away by it. And I may see if I can actually pull out the next witness reaction to this. So I'm going to pause again. Let's see if I can do that, because I do have consent to show. Right, I should have looked up that sooner. I have managed to find out. I'm going to show you a short compilation. So this is the next witness. I do have consent from this channel to show these videos. And this is going to show you the reaction of a number of lawyers. The first one is lawyer, Peter Dragos, and he is watching the evidence presented to the jury, the so-called scientific experiment.
To show exactly how this happened to John O'Keefe.
So I took measurements of myself.
Is Emily D. Baker.
I'm actually wearing the same make and size shoes as Mr. O'Keefe, the same brand of jeans as Mr. O'Keefe.
None of these things are relevant, by the way. Like whether you're wearing the same
Ian
brand of
Runkle,
jeans,
he's a Canadian
completely
attorney.
breaking.
The same brand and size shirt from Mr.
Emily
O'Keefe.
Baker's face.
You see the Lexus
I don't like it.
in the background.
He's dressed
Brother
literally
counsel,
in John O'Keefe's clothing.
Martin,
Wow, he really did the full commitment here.
attorney.
Same brand of
Melanie
jeans
Little.
as I don't even know what brand of jeans they were. He bought those Nikes. Did they have black sole or a white sole? I'm not sure.
This is really strange. I've never seen anything
Is it
about
the lawyer?
accident reconstruction where somebody's actually trying to dress up like murder victim. This is really creepy.
He stood there with a ruler next to his vehicle in the same clothing, same brand of jeans. This is so creepy.
I don't know if you have legal commentary. No, I'm uncomfortable.
We have matched the height to the Lexus.
See, he got a hat that John O'Keefe was wearing. He got the same exact shirt, same exact jeans, same exact sneakers, and he's about the same height and weight of John O'Keefe.
So you're dressing up as a murder victim? You're the expert?
So he's plugging himself into the equation as though he is John O'Keefe.
Happened
Move
short,
forward.
a couple pounds heavier. So basically, he makes the perfect person to use for the demonstration.
This is really bizarre. Why don't you have like a crash dummy?
No, I have never seen anything like this. I have never.
She's speechless.
No. I don't know.
It's funny to watch the next witness because the reactions of these experienced lawyers, these are all legitimate lawyers who some have retired, such as attorney Melanie Little. She is no longer practicing law. Others still are, such as Peter Dragos, brother counsel, Ian Runkle, etc., etc. And they're looking at this, and I'm looking at this, they're having the same reaction as I did. Was like, what is going on? How is this relevant? To dress up in the same clothes and then to demonstrate using paint, the blue paint, to say, well, this is how this, to convince a jury that this is how the injuries occurred. So this is the example, and this is why I put these questions. This is another example of someone from the same company who's looking at the injury, who's hearing what the prosecution is saying, that the cause of these injuries was the vehicle reversing into John O'Keefe. So therefore, he does this demonstration to show, well, see, look, if you stand like that with your arm holding a glass, and then I paint the tail like blue, I am going to make contact with this part of the arm. And see, that's exactly where the injuries are. So therefore, this must be how it occurred. The problem with that is that there were only 9 holes, puncture holes, in the sweatshirt of John O'Keefe. 9. Yet 36 superficial injuries and abrasions to John O'Keefe's arm. So how do bits of tail light pierce through the sweatshirt in 9 places and then cause 36 injuries in different locations? And in fact, other witnesses for the defense gave evidence that the injuries were consistent with an animal bite, specifically a dog bite. Remember, Chloe disappears after the 29th of January 2022. So my question, what scientific basis is there for any test of this nature? What do you base it on? Yeah, speechless. So I hope you found that interesting. Hope you looked to those channels, such as the trial channel, the next witness, and follow them up. Have a look for yourself. And if you want, let me know your own reactions. So for now, ka kite, and I'll have some more questions next time.